Ma'am, we are live now. Please start.
All right. Thank you so much, everyone. Just for the hygiene check, I hope my slides are visible to you and you can see it all and I'm audible. Okay. So I would like to start with a disclaimer that whatever I say today is for the academic purposes, purely for academic discussions, and these are my own personal views and should not be linked to the organization or organizations to whom I am affiliated. At the outset, I would also like to thank NPTL for giving me the opportunity to present today about a very interesting topic on intellectual property and wealth creation. Nowadays, tangible assets are given very less importance as their economic value, we all know, depreciates over a period of time. Whether you talk about an office space, an office infrastructure, or maybe also rather this value of the tangible as things, it keeps on saturating also over a period of time. For example, when we talk about a building, it doesn't increase its value after a few years or so because there is a total saturation in the market. However, when you talk about intellectual property, which is also called as the intangible asset, this has over a period of time has received a lot of importance because the value of IP, no matter what, whether it's number of years which have passed, it continues to appreciate as we speak and as the time passes, especially when we are talking about the trademarks per se and the goodwill that companies are able to generate by selling their quality products or services. For example, when you talk about Walt Disney Company, it sold around 56.6 billion USD worth of merchandise in 2016 alone. And certainly the number has only grown more uh, thus far. There are several other companies, and you've heard them very well, how their brand value increase with several billions of dollars because of the equity, because of the intellectual property that they own, and because of the goodwill that they've been able to generate. Especially when we talk about the startups today, even they are getting highly cautious as to their brand visibility and brand value. Even in Shark Tank, I'm sure this you all know Shark Tank and you must be seeing it. It has become kind of a name in our country. You would notice that sharks who get ready to invest in any startup, they often make their mind basis the brand visibility and the uniqueness of the product or the service. And therefore, they generally talk about what the uniqueness is, whether the startup will be able to defend it in the market or would there be easily amenable to any copying. And therefore, they also ask for whether there has been a good IP protection, whether by way of patents or by way of designs. I don't know if you are aware, very recently in one of the Shark Tank's initiate episodes, there was a farmer, a very young chap, who came up with an engineered products to support farming in the country. And he was even aware of the words such as patents. And when Sharks asked him whether he has patented his work or not, he said that because I don't have wherewithal, therefore he has not been able to do it thus far. But he asked for the help from the Sharks, and Sharks very happily invested in him also, in his innovation, in his technology. So when even at a level of grassroots, people are understanding the value of IP. So I thought maybe today we discuss about how IP can overall help in wealth creation and in overall inclusive growth. Now, before we get more deeper into the slides today and the things that we want to discuss, I thought maybe why not we overall first of all cover the basics of IP. Well, there are different types of innovations and creativity, and different parts of the innovation and creative content can be protected under different IP laws in the country, which is India. And I would encourage the audience who's watching the this presentation for now. Can you please type in the chat box as to which all intellectual property are you aware of? Whether you've heard about it before, and if yes, what are the different types of IP and what can be protected under each type of IP? I think I'll be happy to see your inputs coming up in the chat box. So like I said, intellectual property refers to the creation of one's mind. The one who creates and innovates is granted rights over his work by the federal government through registration of such work under different IP laws. The certificate that is issued by the government to the innovators or to the creators, it acts like an evidence to the fact that the person owns the intellectual property, or he possesses the innovation, or he is the one who actually created it and he has not stolen it from somebody else. Just to give you an analogy, um, uh, you know, it's like when you possess something, some intangible assets such as cell phone or farm land or home, whatever you may possess as tangible property, you are able to prove the ownership to the people to different people that you own it through registration papers or through the bills with the payment receipts, right? So it is exactly the same thing when it comes to intellectual property, your own creative work. You are granted the right over it. There is a certificate issued by the government of India, and that certificate acts as a sufficient testimony to prove to the world around that you are the one who own the work, right? And accordingly, you can then further show that where all it has been protected for a certain limited period of time, which is where you get the exclusive right to work on it. So just to very quickly summarize, there is Patent Acts 1970 in our country. This is the act under which you can protect your technological innovation. So if there is any technical solution to a technical problem that you've been able to come up with, then there is a patent right which is granted to a person for 20 years. And this 20 years starts from the date of filing of the patent application, and which after 20 years is open for public domain for use. Second is Trademarks Act. This is where you will protect your logos, your designs. It is basically the name under which you trade your commodity, under which you trade your product or service. Then you also have Copyright Act. It is the primary conventional source of intellectual property where you protect your work, which is more literary in nature. For example, your computer program codes, your music, film, books, translations, adaptations, cinematograph film. So, for example, if you've heard about Chetan Bhagat's Three Idiot, he is the one who created the novel. But there was another producer of the film, cinematograph movie, who picked up the contents of the novel and adapted it into the form of a audiovisual film. So in this case, both Chetan Bhagat, who is an author, is an owner of the copyright, and the cinematographic film owner who created the entire movie is also the owner of the work. However, he would end up paying to Chetan Bhagat because the content that he utilized to make a film actually came from Chetan Bhagat's novel. We also have Design Act in our country, where it's only the outer aesthetics of the work that are protected. See, generally, when we go to the market, it's not only the functional features of the product that certainly entice us to buy certain thing, but also we are quite amazed with the overall look and the features of the product, which makes us buy one. Okay, so because it's a part of creative work as to how you package your product, how it should look like, the overall outer frame of it. So this is also given protection under the Indian Designs Act, which is where different designs are registered. There are few more types of intellectual property rights which are granted under different acts. For example, there is Geographical Indication Act. There is a even the secret recipes or secret content can also be protected under Trade Secret Act. But in India, we don't yet have the one on trade secrets. It is such works are for now protected under the common law, which is the contract law. So India is yet to witness a specific sui generis trade secret law in the country. We also have semiconductor and layout designs, which is where chipsets and the designs on the chip semiconductors is protected. So this was overall about the types of intellectual property where different types of works can be protected and the rights are granted, right? So now we will look at how intellectual property is not something which is very local in nature. It has become global. Of course, the rights that are granted are quite local because you need to go to every country wherever you want to protect your IP so that it is not misused or abused by a third party without your permission, so that people pay you enough royalty for your work. But intellectual property per se, it has received a global importance. And, nowadays it's IP which is rather used as an economic weapon against the unfriendly nation. And who would have thought that the use of IP during social unrest, such as wars, would be utilized? Use of IP was it was completely unheard of in this way, where it is being used as economic weapon. We all know, we've always heard about use of biological weapons, bombs, missiles, whenever there is a fight between the two nations, or whenever there is a global war. But use of IP to hurt economy of unfriendly nation wasn't really thought of. Things have tremendously changed now. We are all aware of Russia and Ukraine war. Russia has passed a decree that would allow free use of patented software and chip designs and other intellectual property that belongs to Ukraine and that of other countries that are supporting this country, Ukraine. Russia has allowed, upfront the piracy of trademarks or copyrights or counterfeiting. The move, removes any kinds of protection whatsoever, whether it's for patents or trademarks and copyright, which is where holders may have registered from the hostile nations. They won't be able to now be able to protect their IPRs in Russia. So as you can see from the slide, you see the B there, the golden arch, which is a copy of McDonald's because the trademark has been revoked, right? Similarly, people from Russia are now filing trademarks or lookalikes of Starbucks. Um, so this is what has been happening, and the sanctioned list currently includes US, Australia, Britain, Iceland, Canada, New Zealand, and so many other countries. And the McDonald's trademark and the lookalikes, like Uncle Vanya, are seeking registration of their trademark without facing any consequences of infringement. So this is the level where IP is now being used as an economic weapon to against the unfriendly nations. Moving ahead, let us look at some statistics from International IP Index. So this is GIPC is the one which annually monitors different countries and their IP environment. There are some stats from top 5 IP systems. Let's say in Singapore, Japan, South Korea, Switzerland, and US, where it is stated that these are the top 5 economies where IP is adequately protected. As a result of very good or adequate IP regime, these 5 nations, these 5 economies have been able to witness certain interesting facts. For example, in these 5 nations that I just mentioned to you, there are 38% more startups in these countries that are more likely to attract venture capital fund and private equity, and they have 2 times more innovation output. These countries have over 550 more high value innovations that have been patented per million population, besides having 5 times more knowledge output in scientific and technical journals. So imagine that if there is adequate IP protection in any country, these are the interesting results that we are able to foresee. And that is probably the reason why India announced Startup India and Atmanirbhar Bharat, uh, where our existing government wants to see India to remain Atmanirbhar for any kind of product and services. And therefore, there is a lot and lots of focus given on startups to innovate, to protect their IP. In fact, any of the Indian startups that wants to get registered under DPIIT and the Ministry of Commerce, if you look at the definition of startups, there is a word called tech savvy. There is a word called IP savvy, right? Um, and you see that only those startups can get a registration in the country in India, those who are able to prove that they've got enough IP. And otherwise the registration is not possible. You need to show your patent numbers, you need to show your trademark numbers, whatever is the IP worth that you have, that you've been able to create. That is what you have to provide in the form of an application, and then only one gets registered in India. So anyway, we were talking about top five countries which were monitored by GIPC. There are several countries monitored, but top five are the ones that shows these interesting results. These countries are able to attract and host 10 times more clinical trials. And you know that whenever there are clinical trials, it becomes important for the pharma sector to come out and produce more safe and effective drugs for the patients. And therefore, clinical trials are very important to support the safety and efficacy of drugs. But it depends as to where would pharma industry will be confident enough to get their clinical trials done, because even the data that gets generated as a result of clinical trials is an intellectual data, is an important data. And they want to invest in only those countries where there is an intellectual property safeguarded, right? And these countries also have better access to legitimate videos or music through a secured platforms. Otherwise, you would have seen a lot of pirated sites where you see a lot of pirated music and film and a lot of counterfeit products. But this leads to a lot of loss, not only for the creator but also for the economic loss of the country, because it supports unorganized crime. However, in these top five countries that I just mentioned, there is an important enforcement of IP, there is an adequate IP environment. You don't see this piracy, perils of piracy are not seen, and therefore these countries are able to grow better. Let's move ahead. Uh, when we are anywhere talking about the importance of IP, I think it's not only important to keep filing your intellectual property for the sake of numbers. No, you need to make sure that it is not only filed, but also it is granted. Once it is granted, it is safeguarded through appropriate mechanism so that it is not misused. See, once you've got the IP granted, it's not sufficient, because otherwise it's nothing but a paper tiger. Unless your IP is strong enough and has a enough quality that it is able to sustain the test of market, right? You need to be able to monetize your intellectual property. You need to be able to create intellectual property in such a way that is commercializable. Now, just to give you an analogy and a metaphor, let me say, we all have seen movie Three Idiots. I'm taking the example once again, and there is Funsuk Wangadu, and there is Chatur Ramalingam, who is ready with a check to give to Funsuk Wangadu, for because he is the one who owns 400 patents in his name, and this person who the other person who's standing with a check to pay to Funsuk Wangadu is ready with a whole paycheck out, because he's working for a Japanese company, and Japanese company wants to use these patents. But well, in reality, it's not as simple. In order for you to be able to commercialize your intellectual property, for you to be able to bring it to the market, for you to be able to get in touch with the right buyers, you need to make sure that your IP has a value. It should not just be a paper, it should have a commercial value attached to it. And that is where a lot of importance of not only the innovator per se, but he has to make a group which should have a lot of other people who bring in more skill set to bring a value to that IP, and which we will study as we move subsequently in the forthcoming slides. But for now, at least in this slide, I wanted to tell you that as much that you can do, whatever things to monetize through your tangible assets, whether it's your home, your land, your infrastructure, or whatever you may have, exactly same things that you can do with your intellectual property as well. Else, there would not be use of IP, because people don't really appreciate the value of intellectual property because they have not tasted the flavor of it getting, commercially workable, where from local to global, people should be able to go. Maybe you produce the innovation while being on Indian soil, but your innovation should be of such nature where you can take it globally. Now, what all you can do with your intellectual property is this, and you can draw the analogy between the real estate property and the intellectual property. So, for example, startups, I want to draw a parallel between the two. Startups can be compared to constructing a building, thereby building your own company. Similarly, sale or assignment of intellectual property can be done similar to selling a piece of land or any other tangible property in return of a lump sum payment, right? This leads to transfer of the complete ownership of your intellectual property to someone else because you've sold it, you have assigned it. But in return, you get lump sum payment for the work that you've done. Similarly, we also have another way of monetizing your intellectual property, that is by way of licensing, which can be compared with renting your house or your land, where there is a regular source of revenue over a period of time. For IP, when we talk about licensing, it provides royalties, which can be further utilized in boosting the innovation cycle. You can put back the money, some percentage of money, back to the R&D to come up with further innovations. Similarly, we have heard about, if we were to talk about if there is any key example in IP licensing, if any company has been able to successfully use. Well, there are several examples to name, but IBM comes quickly to my mind because we see a lot of literature around it whenever there are academic sessions. And actually, more than 1 billion US dollar comes from IP licensing revenue to IBM and not really out of its sales of the products or services. Thus far, 27 billion USD in total out of IP licensing. So this is all what IP can do for you if in case it has commercializable product. There is another opportunity where IP can be monetized, and that is through franchising. We see franchising a lot of times in FMCG companies, whether you talk about KFC or you talk about McDonald's or Starbucks or Cafe Coffee Day. These are the areas where you have seen the franchising happen. In this case, IP franchising leads to receiving royalties while continuing to grow your brand. So it's some other party working on your work, on your invention, but you grant him the rights to use your trademark because of a certain goodwill that has been produced. And in return, not only the person who has got a franchisee gives the royalty, which is one-time franchisee fee, but also for every sale of the product, right? Every year, it could be 4 to 5% or whatever the negotiations may have taken place. But this is how the owner receives the royalty. The the last is the litigation. Well, I wouldn't say that litigation is the way to make money, for sure not, because litigation is the last resort that any IP owner would want to have. Generally, all IP owners or majority of the IP owners would want to have good faith negotiation where they are ready to give out their intellectual property either by way of sale, assignment, or licensing or franchising. But if in case the other party doesn't act in a good faith and the other party just continues to infringe it, then that is where the court doors have to be knocked for seeking the reprieve. But the fallout, where if IP owner wins, then he receives the profit of sales or damages on the accounts. So this is how it works as far as IP monetization and commercialization of intellectual property is concerned. When we talk about startups, they've been able to become unicorns today, and we know certain names, whether it is TCS or Wipro or Infosys and several other companies. Those Indian hardcore indigenous companies, they were not as big as they are today. Many years ago, they also started as startups. Some companies that we know today have become global leaders, and the very reason why they've become global leaders, one of the credit goes to their early understanding of the value of intellectual property, right? Today, these companies work for several multinationals across the globe to develop certain customized products, innovative softwares, and earn through it. And percentage of these earnings are then further invested back into the R&D to develop more and more flagship products. In fact, some of these Indian indigenous companies have been receiving a lot of awards because they've stood out to be the top 20 filers of the intellectual property. Well, it is well established fact now that countries that provide effective IP regime, they turn out to become better economies, not only in terms of their contribution that intellectual property brings to the country's GDP, and this is the reason why India also pushes a lot towards, as I said, about Atmanirbhar, where there is a lot of innovation coming in, where you create your domestic IP and then sit at the negotiation table and cross license. Sorry, is there somebody who wanted to say something? I just heard a voice. Do you want me to stop here? Okay. So it is well established fact now, as I said, that countries that provide effective IP regime has become, they turn out to become better economies. And this slide shows you some interesting stats coming from EU, right? European Union. And there is a better performance, not only in terms of the companies that are working in the European Union to be the better pay masters, but also their revenue stream increases because there is a lot of innovative product and services that they're able to create and protect and then enforce. Um, just to give you certain stats, companies which own at least one patent or a registered design or a trademark, they've been able to generate 20% higher revenue per employee than companies who do not possess any intellectual property. Further, these companies are paying 19% higher wages than other companies. Similarly, if you look at the companies with a lot of design registrations, they earn 32% higher revenue and they pay 30% higher wages to their employees. We've also seen that the companies that own a good portfolio of trademarks, these companies pay 21% higher revenue and 17% higher wages. Now, when we talk about startups or SMEs that combine different IPRs, they even enjoy higher revenue per employee. So, if today you look at startups today who now, I mean, startup has become a buzzword. Everyone wants to have their startup because they don't want to work under a boss. They want to have their own product line, their own. They want to be their own bosses. They want to grow, and they want to get a flavor of that market and how an entrepreneur works. Today, if you really understand that the kind of startups that are emerging, they definitely, if they want to sustain now, people say that okay, there are so many startups opening up, but how many are able to sustain for over a period of years? Are they the quick ones to exit from the market? Well, those things are also correct because the startups, they open up fast and they lose the market also very fast. It's probably because they are not into R&D. It's probably because they are not investing in innovation. It's probably because their products are not able to compete with highly innovative companies. And therefore, startups, even you, if those who are students here, those who are professors, universities, who are protecting a lot of patents in India, um, and what we've understood that as we speak, 45% of domestic filings are actually coming from the domestic filings, from domestic innovators. Uh, and many of those out of this 45% actually are emerging from academic sector. And many a times also the professors, they open up their own startups. So it becomes extremely important that if you are going to open up a startup or you have a startup today, you need to place enough importance to intellectual property so that you are able to not only increase your revenues multiple times, but also you should then be able to pay out to your employees as a result of the innovative products and the IPRs that you own. So when we talk about the EU, the small businesses that own both patents and trademarks, they generate 75% more earnings, while those that have registered designs and trademarks have estimated revenue premium of 84%, right? So this is the value of IP. SMEs that own a combination of all of these intellectual property, they have almost double the revenues, 98% the revenue per employee compared with the companies that don't have intellectual property or any sort of a portfolio. In fact, if you look at the web today, uh, and I gave you the example of Shark Tanks we see every day on our television. Many of the sharks, they are able to make decisions just because a startup that has come for an investment, it is able to show the niche by way of IP protection, right? So one must start caring about IP and how to monetize it through different ways I just mentioned to you in some of the previous slides. Now, what is, if you talk about valuation, now I'm saying that IP has to be valued. There has to be some MRP placed on every IP that you create or a portfolio that you create. The valuation is a very important activity. Unfortunately, we don't have yet a lot of valuation experts as we speak in our country, but this is the pool of talent or the talented skill set that is required in our country, who can help Indian startups, who can help professors, students, universities, companies, SMEs to value their intellectual property. Because creating an IP is one thing, but bringing it to the market with a certain value is another. And then finding out the right buyer who will be happy to buy your invention or license in your technology is a completely different ball game, right? Which requires for an innovator first himself to have a confidence what his innovation is worth of, right? And this is where valuation of IP is not one person's show. It's not that I, as an innovator who may have created something and I put X amount on my IP. It doesn't work like that. In reality, it just doesn't work like that. There has to be a combination or a pool of talent skill set. For example, not only you need an innovator for to identify what the intellectual property he or she has come up with and what is the effective contribution to the consumers once they start using the intellectual property. You also need a person who understands business, who understands market, who understands numbers for appropriate valuation of intellectual property. One also needs a market analyst or market analyst who can identify the readiness of consumers for that particular innovative product or a service. A chartered accountant is also required to understand very well as to what all are the compliance laws, whether in terms of tax laws or any other, that needs to be complied with by a business, by a company, by a startup, by an innovator. Similarly, you also need in this pool a patent practitioner who can help in adequate protection of the work, facilitate in getting the rights from the federal government. You need a policy person who can then understand the gap areas, any opportunities in terms of the IP environment that exists in the country. Similarly, an assertion team is also required, some representative from the litigation team who can then protect the innovator in case there is a misuse of his or her IP at a later stage. There is also a need of an IP analyst who can continuously give feedback to the innovator to identify certain unexplored areas of technology where further innovation can take place. Because coming up with a product once is not going to solve the problem. Once you have come up with a product, there has to be engineering over and over above it over a period of time so that more value based products can continue to come into the market. So when you talk about IP valuation, I mean, it becomes very fancy where I hear people saying that, oh, we've got such a big portfolio of intellectual property, we've got so many patents filed, so many trademark applications done with, so many trade designs registered. But the question is, how many of these have you been able to really commercialize and monetize? Did you ever sit with anybody who understands litigation area? Did you ever understand with a person, sit with a person who understands business in the market? Did you ever sit with any government officials who, or a policy person who can give you information about how would your intellectual property fare well in the country, right? I can bet you may not have, right? And this is the thing that you now have to start working on, because it might look very easy to maybe just give a presentation on IP monetization, commercialization, valuation, but unless you sit in reality on ground with different set of people I just spoke to you about, valuing your IP will not be complete unless you have a value and an MRP or certain sort of valuation attached to your IP. You cannot go ahead in the market and ask for look for the buyer, look for the licensee, or look for an assignee or anything, right? Let us look at further about and we discussed about different ways in which how you can monetize your you can work around your invention and bring it to the market. So one of the items is IP sale and assignments. So IP sale or assignment, it is one-time transfer of the ownership of complete IP to somebody else in return of a lump sum, generally. And IP rights are transferable rights, right? Where there is a transfer of title, ownership, right to use, right to license to further somebody else, and any other economic rights. Now, there could be a complete assignment, there could be a partial assignment. When there is a complete IP which is assigned, then there is a complete assignment or transfer that happens. Assignment of IP can happen also in the form of a bundle, where it's not only patents, but you assign your copyrights, your trademark, whatever design attached to it or associated with it. You give a complete bundle of IP to somebody else. This is what a complete assignment would look like. And generally, IP assignments are for the complete full tenure of the intellectual property. But if it's a partial assignment, then generally assignments or agreement take place for 5 years, and then again negotiations take place, and then you decide the further course of action. It could be territorial in nature. Sometimes, the IP is transferred by way of which country you are giving the rights to somebody else to use, or some part of the innovation or something. But there are a lot of nuances attached to it. If I were to give you some example of, has there been successful example where complete bundle of IP may have been assigned to somebody else? BlackBerry comes to my mind, that earned 600 million USD in patent sale agreement, right? As a result of agreement between BlackBerry and Catapult IP Innovations for the transfer of all BlackBerry's non-core patent assets. However, patents that are being currently used by BlackBerry's core operations, these have been excluded from the agreement. So when you sit with somebody and you want to sell or assign your IP to somebody else, you need to see that what area of R&D do you want to continue to work on and retain that IP with you. But give away the IP for the domains, for the sectors in which you may not be doing certain further work, or you may have made up your mind to shift to somebody else, some other work or some other area of technology. Now, this was more about patent assignment and transfer of the IP rights. When you talk about copyrights, there is also called as moral rights, and these moral rights are not ever given away. And therefore, if I were to take an example of book publishing, maybe you've come up with a book and you've assigned your IP to a book publisher, but your authorship will always remain, right? Therefore, you always see your name as an author in the book, while the copyright may have been transferred to somebody else. In the moral rights, there are two types of further rights, like right to paternity and right to integrity, which means even if after you've given your copyright and you've assigned your work to somebody else, that somebody else cannot ever mutilate your work. That is where integrity of your IP has to be safeguarded, your copyright has to be safeguarded. Similarly, there is always a right to paternity, meaning even if you have assigned your work to somebody else, you remain to be the real author of it. And therefore, whether it's a book publishing, or whether it's a singing of music or sound recording, cinematograph work, the name of the singer, music composer, or any other underlying works, it always remains with the author. Now, going forward, the IP licensing is one way. And as I have told you, IP licensing is another way how you sit with the licensee, between the licensor and the licensee, the negotiation takes place. And this is always a handshake. It's never an imbalance, right? The interests of both the parties are seen for a win-win situation, and therefore good faith licensing, where both of these parties understand each other's interest areas, where you then mutually decide how the royalties will flow, wherein you also decide mutually the time period for which, during which the licensing would remain in active stage, or you also identify these certain areas of intellectual property where you want to license out and license in. All those kinds of things are seen in the case of IP licensing. The only difference between the assignment and licensing is that in the complete assignment, you have transferred your right, complete transfer of rights to somebody else. However, in licensing, you retain your intellectual property, the ownership, but you license it out to somebody else for a certain period of time. Now, this licensing could be an exclusive license, it could be a non-exclusive license. If it is an exclusive license, then even the patent owner or the IP owner is barred from using his IP for that particular period of time. It's so that there is no competition, right? So that the other party to whom the work has been licensed should be able to explore the market fully well. You may decide to divide the geographies, you may decide to divide the products basis which you want to license it to somebody else, whether it's exclusive or non-exclusive. All of that can happen. Going further, there are different ways in which royalty sums can be negotiated. It could be a fixed royalty. It could be an aggregate amount that the licensee must pay to obtain the rights to use patented technology during the term of a license. One-time payment for the license could also happen. It could be a fixed royalty also. Royalty is fixed for, let's say, number of units or per month or per year for that license. For example, let's say if there is hypothetically 2 rupees for the sale of per unit of the product, then you have a multiplier per month, and then you get a certain royalty. Say 24,000 rupees, or if it's 3 rupees or 4 rupees per unit, and you multiply it with a month, and then you get the royalty amount. It could also be running royalties, and running royalties are defined as the payment received by a licensee, the amount of which is based on the manufacture, use, sale, or distribution of the licensed product. For example, it could be 2% of the net sales price or 2% of the gross revenue. So generally, whenever you sit for royalty negotiations, whenever licensee and a licensor are sitting together, they might come up on mutual terms and conditions and what they feel is the best for both the parties. It could be a mixed sort of royalties. It could be a fixed one coupled with running royalties, and or it could be just also a combination, or an upfront lump sum royalty could also happen. So there are different ways, and there is no one standard box that I can tell you, okay, this is the thumb rule. No, it doesn't work like that. IP licensing is quite unique in nature. It completely depends upon who your licensee and your licensor are, what their product line is, what their extrapolation in terms of market is, what kind of products are they willing to sell, whether they want to sell it in India or other parts of the world also. Now, what is the health of the other party who is wanting to license in? A lot of things are actually seen before finally coming up with the final royalty amount. Um, so this is about the franchising as another way of monetizing the IP or commercializing your intellectual property. As I already said, that there are a lot of franchising that has been successfully. We all have been able to see, whether it's McDonald's, Pizza Hut, Domino's, KFC, so many other companies, and we see how their brands they've been able to establish globally. I encourage all of you to watch movie The Founder, where the real owner of the trademark had to wash off his hands from any sort of royalty payouts to him because of some mistakes that he did. He was not really aware of the nuances of intellectual property and how to safeguard his trademarks. And therefore, this is an appropriate story, a real story of riches to rags, where in spite of having such a good product, in spite of having such a nice trademark, the owner was not able to retrieve any benefit out of his intellectual property, and it actually went in the hands of a businessman who understood business, who understood market. And therefore, I continue to keep on reinforcing that IP valuation is not a job of a single person. If you are a creator, if you are an innovator, an entrepreneur, you need to understand that you need to take help of other people also who understand market, who understand litigation space, and who have got nuances of all other things that I talked to you in the previous slide. Um, so if you look at the McDonald's franchising, McDonald's, it's a worldwide global food service retailer, and we all know. Overall, there are 38,000 locations in over 100 countries, and approximately 93% of McDonald's restaurants worldwide are owned and operated by independent local business owners. In fact, royalty fee per franchisee that McD's get is 4% of the monthly gross sales. And if you look at the franchisee fee, the one-time franchisee fee per location that one has to pay is 45,000 US dollars. So this whole data is captured from the public domain information only. Term per franchisee location is for 20 years for an agreement with certain renewability terms and conditions if the person to whom the franchising has been given does the work as per the norms that have been given. Total revenue earned through franchising in 2018 alone was close to 100 billion, 11 billion US dollar, over 50% of the overall revenue. So this is one successful case of McD's where the owners, while they were out in terms of being able to receive adequate remuneration, but it was somebody else who understood the market, but was able to take McD's to a next level and produce a lot of brand equity for it. Well, IP litigation is, I wouldn't say that this is the way which should ideally be used at all to receive revenue or remuneration. It is only a last resort when licensing fails, when IP franchising fails, when IP agreements fail, assignments fail. It's because the other party may not have been behaving in a good manner and continues to use the intellectual property without paying adequate remuneration or without the permission of the owner. And that's when you have to go to the court to ask for a remuneration, ask for the injunction to stop the infringer, ask for the profit or the accounts to see what profits has the other person been able to make, to find out what damages have been accrued to the IP owner. But yes, IP litigation should not be seen as a sin. If somebody is going to the court of law to ask for a help, to ask for a relief because IP has been getting misused by a third party, should not be seen with a bad eye, right? Because if you've done so much of mehnat and lot of effort to get your IP created, then protected, then also bring it to the market, certainly you cannot give it away just like that. And when people go to the court, they should go with a clean hands, with the right facts, and in a timely fashion, to make sure that IP is enough respected. Well, it is 6:53 and we started at 6. I think I was given 45 minutes to talk to you about generally the nuances of IP monetization and IP wealth creation. But I really encourage people here to register for some sort of an IP Olympiad or IP test where you can test your own knowledge, right? And there is one that we have in our country, which is Intellectual Property Talent Search Examination. This has been there since 2018. There are several government bodies that support this initiative. One second. So there are different government bodies that support this initiative, whether it's AICTE or Inspire Manak, iHub Gujarat, or Ministry of Science and Technology, Ministry of ICT, METI Startup Hub, PSCST, and NRDC. There are so many government bodies that are supporting this initiative. It's been 4 editions have already been done, and fourth edition awards are now slated on 19th of April, which is where it is being done by FICCI as an award partner. And there are several other partners, a lot of educational partners, including Ericsson, that has been supporting this initiative, because we believe that if there is enough IP literacy in the country, it can do justice and it can really bring a country to the next level. And these awards are not only basis the good marks that you receive as a result of this IP Olympiad that you take once a year, but also there are a lot of added benefits, like those All India rank holders, they get the opportunity to intern with a lot of corporates and with the IPTSE Academy that organizes and administers these awards. There are cash rewards also provided. There is a trophy, there is certificate. So it all helps in boosting your resume. Because today, when you go to any corporate, any IP savvy corporate, I would say, learned corporate, they would ask you during the interview as to whether you are aware of IP or not. Have you been able to gather enough knowledge that you can support your own work in the organization, but also help organization to grow? And IP is not limited to a particular domain, right? Even if you're an engineer who will be doing some work in R&D center of different companies, or you are a designer who will be working in some media and entertainment industry, or you are a social media enthusiast where you'll be creating a lot of contents for YouTube and for so many other social media handles. Everywhere intellectual property is dovetailed. You need to make sure that your work is original. You need to make sure that you're not copying the images and work that actually belongs to somebody else. Even if you want to use someone's work, you should know the nuances as to what is the limit that you have, to the extent to which you can use it. So these are all the nuances that you learn as you register for the intellectual property talent search examination, which is also called as country's first of its kind IP Olympiad. There is a dashboard which is provided to the registrants. They undergo a lot of reading material. They are also given a lot of webinars, and finally they sit for the test for an exam. This is all online, and fifth edition registrations hopefully will be started by the IPTSC Academy in June, July something, and you can keep track of the IPTSC website to register for it during that time, and keep track of various social media handles. But this is a good program which has been devised by a lot of people together. So it's a brainchild of a lot of people, which is now administered finally by a startup, which is being supported by all of us and many of us. So I encourage you all to be part of this, and benefit from it. I think this is what I wanted to present for today, and I'll just put stop this screen share. I think I have stopped it. So with this, if there are any questions in the chat box, if the organizers want to tell me, I'll be happy to take it now. Else, maybe we can post it at a later stage as well, as you may say. Okay, I hear none. So with this, I think if I have a permission, I'll be back soon. And if you have any queries, please do reach out to me. Feel free. You can reach out to me at the number that NPTL will provide, the email ID, and I'll be happy to see you in the fifth edition of the IPTSC Awards and the IP Olympiad. Well, thank you so much. I thoroughly enjoyed being here today, and I look forward to being part of more such webinars and workshops. Thank you so much.